Okay. So the next thing, I think that good thing people would like to know is, why don't you explain to start with, how does a person get a divorce when they've decided that they don't want to be married anymore? What do they do?
Well, you have to file what's called the summons and petition with the court. It's judicial council forms. It's FL 100 and FL 110. The petition is FL 100 and the summons is FL 110. So basically, those are the two primary documents you file, and it tells the court that yes, you're interested in filing divorce on whatever grounds you choose within the petition, and then it starts the process from there once you file. You have to meet the jurisdictional requirements as well to file divorce in California, meaning that you've been a resident of the state of California for 6 months and a particular resident of that county in which you filed, or which, for 3 months.
Okay, and then is there a filing fee, or is it free? How much does it cost?
Generally speaking, in Riverside, generally speaking, in Los Angeles, in San Bernardino County, the filing fee is $435. That's what they call the first filing fee, first appearance fee. In Riverside County, the first appearance fee or filing fee is $450, and that starts the process. They do have what's called a fee waiver. That's a whole set of forms that you have to fill out and ask the court to look at your income and also your respective expenses, monthly expenses, and they'll determine from there if you qualify for a fee waiver or reduction in fees.
Okay, and then after you do that and you pay, or you get a fee waiver, you then have to serve the other spouse, right? Serve
Yes.
the papers on them, right? Can you serve it by mail? Do you have to serve it in person? How do you serve them?
Well, service, of course, means putting the person on notice that you filed for divorce. So it could be anyone who's over the age of 18 who is not a party to the action. So that would not be you, of course. Some people can go use process servers. They can contact their local sheriff's department. You could have a friend or a relative serve the paperwork as long as they're over 18 years of age. So that's personal service. If you were, let's say, to serve the person by mail, then they have to fill out what's called an acknowledgement and receipt and sign that and return that to you, saying that they have acknowledged that they've received the papers in the mail and they're accepting service.
Once the person is served, how long does the person have to reply to your petition? And what is the reply called?
So generally, a person has 30 days, calendar days from the date they were served, to respond, and that's called the response to the petition. So that is the FL 120, and so the clock starts as soon as they're served. So if they do not respond within the 30 days, you can petition the court at what's called a default. You can ask for a request for default.
And what does that do? If you ask for a default, what happens?
Well, when you ask for a default, you're asking the court to proceed with your divorce papers because the other party hasn't answered, and you're asking the court to award you whatever you had outlined in your petition for as like a community property and separate assets. And
so
and then
let's say, okay, go ahead.
Oh no, and then in addition to your default request for default, you would file a default judgment, further explaining to the court that these are the court orders that you'd like the court to put in place.